Yes.
Worship, I need to mention item number 5. Worship, here I received only recently that the instruction from the department.
Hmm.
So 2 weeks time will be granted.
You're that indigenous certificate.
Yes.
Lordship, I have no objection. Lordship, because there's a recent development and I am required to
See, a
file.
person with his background,
My lord.
why is he being troubled so much? Huh? Means he is part and parcel of the Naga
Yes.
history, you can
Yes,
say.
yes, my lord.
The troubled times he was here,
Yes, my lord.
and still he is not getting an indigenous certificate.
We're very unfair. Yes.
Yes, when?
After 2 weeks,
Okay. You are for the comment.
state respondent.
I think we got to look into this issue. On the prayer of Mr. So-and-so, learned government advocate appearing for the respondents and not objected, on the prayer of the so-and-so learned government advocate for an adjournment in the matter to complete his, facilitating him to complete his instructions, not objected to by the learned counsel for the petitioner, registry to list this matter again after 2 weeks on a date to be fixed by it. Let's see, next time maybe.
My lord.
Worship, I have another matter, item number 9. This is also covered by the reservation policy. So 1 week time will be granted. I have already
The
completed.
matter is already settled. Why this?
The policy is still going on.
Mr. Jamil, this issue, the High Court had settled.
Correct, Lordship. No.
Mr. Jamil should have been here on a contempt,
No, Lordship.
right?
Lordship, on this issue, the government of Nagaland, they have constituted a committee and it was dissolved, and only last week they constituted a committee to look into the reservation policy.
But in the meantime, the High Court directions are there that have to be complied with.
Yes. So particularly on this case, I for 1 week time.
It's only with regard to certain specific posts in that advertisement.
No, it is not.
What do you say, Mr. Jamil?
It is for reservation.
Lordship, if Lordship look at the order 24/10/2025,
Time was given.
2 weeks time was given as a last
Yes,
chance.
yes.
Because time was sought for by the government since last year.
So
So to my understanding,
now
last,
that last chance is given, how can I give a last chance?
Lordship,
So I'll have to impose certain cost for that.
Lordship, the problem with me is I have already completed the affidavit. And because of that, the process is still going on.
that was the submission for the last
Yes.
3 months, Lord.
What we do is we'll take up the matter and at that time, see how we can accommodate you. Because it's the last chance already given.
Yes.
So again, a last chance for last chance, how can I?
So
We'll pass some others, don't worry. We'll not get into trouble, but we'll have to find a way out. We'll do that when the matter is taken up. Okay.
That's Lordship. Lordship, I beg my item 6. Lordship, is the matter can come up after 2 weeks, Lordship?
6 is already mentioned, I suppose.
No, Lordship.
You had mentioned item number 5. Okay. Why?
Lordship, the leading counsel, Mr. P. Surain, he's not getting well.
Oh,
Kindly let it come up.
drop the prayer for regularization.
Lordship, I'm here only for the eco
Pay parity. But you will have to establish that you seem going. Consider, why we are here.
May I please, my lord, your lordship, in this matter is handled by my colleague, Kian Rami, your lordship. Your lordship, he is also not well, your lordship. So,
Okay, on behalf of the Islamic Council for the Parties, registry to list this matter after 2 weeks on a date to be fixed by it.
deeply obliged, my lord.
May I please, Lordship? My lord, I beg to mention item number 18 to form the supplementary cost list, my lord. My lord, this case was handled by my senior additional AG, and the case has been entrusted to me, my lord. So kindly allow me 1 week.
You are for the government.
Yes, Lord, my lord.
Why? We kept it today,
Yes, my lord.
yesterday.
Kindly allow me 1 week time to go through the file, my lord. This was handling by my senior additional AG, my lord.
They are all wardens.
Yes.
Warders. And it is their case that there is no differentiation between the work done by them and the regular wardens. And you have not denied that aspect in your affidavit. And see, the work they do it on rotation basis. So today she is there, tomorrow a regular man is there. What is the difference? Why are they not? They are still in the old ROP minimum and not in the new. That much only. And see, the beauty of this bench is you have a body of judgments on that only, on that aspect only. And it was upheld by the Supreme Court. How can I, as a single puny judge, go against that?
Yes, my lord.
Okay. I'll give you an opportunity.
Yes.
I read the file only for 1 hour. I'm giving you time till 2 o'clock. You go through debrief. Show me one distinguishing factor. Stop me. I'll not proceed further.
Then let the matter come on Thursday, my lord. Thursday.
Oh, you're putting me into. I've already kept Mr. Jami's matter for delivery of order on Thursday.
Kindly, my lord.
Yes, what do you say?
My lord, I'm ready for today, but then if that is the case,
Okay.
I'll be taken up on Thursday, my lord. But
Okay. I'll
Let-
I'll reduce my workload. I'll hear you today. I'll hear him on Thursday. Done.
Okay, man.
But Thursday?
Sure, man.
after 2, my lord. After 2 or
No, not today. When the matter is called up.
My lord.
obligation.
Yes, madam.
Chief, I'd like to mention item number 15, hearing item number 15. Lordship, there are some new developments here.
That's what you were been saying last date also.
Yes, Lordship, we filed an RTI and only after we appealed. We have
No,
received-
madam, there was a selection.
Yes.
What happened to, what is your position there in that selection? See, you did not have the qualification, but you participated in the selection process. Have you been denied the appointment on the basis of your merit or on the basis of your qualification? What is the position, ma'am?
Your lordship is, I mean, the petitioner is unsuccessful. After,
See, there is a catch here. If he is unsuccessful on merit, that is one aspect. If you have rejected his case on the basis of qualification, that is
no,
another.
no, that is not.
Can you make a statement to that effect?
Yes, your lordship.
If you want, you can have your instructions.
Yes, your lordship.
If that be the position, madam, we can't proceed with this matter any further.
Lordship, we are aggrieved by the interview process because
That
that
No,
is
they are
the
pretty-
new development, Lordship, so
They are challenging the advertisement.
challenge the advertisement, madam. That advertisement you have been held to be, the only ground of challenge was that you did not have the qualification. You said it's only a knowledge in Nagamis, Hindi,
Yes.
English. After the orders of this court, they permitted you to appear. So that aspect is gone. So if you want to have a better challenge, two things you'll have to do. You will have to bring in pleadings. You will have to implead the person now selected for appointment.
That's right.
So in this proceeding, what can this court do?
Yes.
Lordship, if necessary, after checking the documents,
no.
we'll file.
Do this if you want, I'll give you liberty.
Lordship, we wish
I'll have to dismiss this.
Lordship, we
Yes.
wish to bring the new development.
I know that you bring it. You bring it, that what you wanted last week also. Let the matter be called up, ma'am.
Lordship, public.
May I please, your lordship? I beg to mention item number 3 and 4.
There was a,
Is I'm
your
Okay.
body.
For the respondent number 6 in item number 3 and respondent number 4 in item number
Same respondent.
same.
Prayer is made on behalf of the private respondent.
Yes, your
For
the
a-
matter may be if the matter may be listed after 2 weeks.
Prayer is made on behalf of the private respondent in the above noted writ petitions for an adjournment in the matter by way of circulation of a memo. Prayer is not objected to by the learned counsel for the petitioners. So accordingly, registry to list these matters again after 2 weeks on a date to be fixed by.
Like your lordship.
Please, your lordship, I beg to mention item number 12, hearing item number 12 on behalf of Council for the additional transition.
You are for the petitioner.
Yes. The senior council is indisposed, so if matter can come up after one.
I'll not pass any adverse order. Okay? Enough for you? But I'll take up the matter. I just want to know a stand from the respondents. Okay? I'll not dispose of the matter, don't worry. But I'll ask them something. Any problem?
The senior council is indisposed. so-
I will not trouble you. I will not dispose of the matter. But this is a matter pertaining to pension. Let me have, madams, I want to have an interaction with the government council. They filed an affidavit. We'll take up the matter when it is called. And I assure you, I will not touch it. If I can allow it, I'll allow it. I'll not dismiss it. Any more assurance required? Be here when the matter is called up and go through the file once. Yeah. Yes.
From the supplementary cost list for motion, item number 16.
Yes.
Lordship, custody battle between husband and wife,
And the
child is in between.
child is being pulled
Yes.
to both extremes.
Lordship, if I may get straight to the point, without wasting your lordship's time. There's a very recent decision of the Honorable Supreme Court. Decision dated 9/4/25. May I place this before your lordship?
Please do so.
We can start from paragraph 3, a little bit of the facts, my lord. Paragraph 3. Then 4, 5, a little bit of the facts. Then paragraph 7. Paragraph 8 is the order of the High Court, which was assailed in the SLP. The decision starts from paragraph 19. Main B is what is relevant to the as far as this case is concerned. Same here, my lord. The daughter is just 3 years and 7 months old. And the mother has already had been the primary caregiver since birth.
When I was going through the file, that is the only thing that I noted.
Yes.
But I can't pass a order reversing this without hearing the other side. We'll issue a notice. And with regard to the overnight visitation rights given, we'll stay that.
Very well.
Heard Mr.
Hold the moment.
जो भी learned counsel just लिख देना. Also heard Madam Yon,
Libika yun.
learned government advocate. You are government advocate.
Yes.
Government advocate. Appearing for the respondent number 2. Issue notice, returnable 4 weeks. Also, Ms. So-and-so, learned government advocate, accepts notice on behalf of the respondent number 2. No formal notice is required to be sent. However, requisite extra copy of the writ petition be furnished to the learned counsel for the respondent number 2. Also, petitioner to take steps for service of notice upon the respondent number 1 by way of
Speed post.
speed post. Steps within 2 working days from today. The petitioner has prayed for an interim direction for heard the learned counsel for the parties, learned counsel for the petitioner as well as the respondent number 2 on the prayer of the learned counsel or the prayer of the petitioner for passing an interim direction in the matter. So, considering the nature of dispute arising in the matter and the tender age of the daughter of the petitioner and the respondent number 1, who is stated to be around 3 years, 7 months, this court, considering the background of the litigation history available in the matter, of the considered view that for the interim, the direction passed by the Principal Judge Family Court, Kohima, Nagaland, by order dated 3/11/2025. That's the order
Yes, madam.
in IA bracketed C number 5/2025 bracket in custody case number 1/2025 to the extent of granting overnight visitation rights
Overnight
to
custody, madam.
overnight custody to the respondent number 1 of the minor daughter of his minor daughter shall remain suspended. The directions contained in the order dated 3/11/2025 read with the earlier order dated earlier order
Earlier order is dated 5/25, madam.
10/3/2025.
8/3/25, yeah.
10/3/2025 with regard to visitation rights of the respondent number 1 herein shall however be complied with by the petitioner as well as by the respondent number 1 as directed by the Principal Judge Family Court. So, the above order would be further considered. The above interim directions passed would be further considered on the appearance of the respondent number 1 in the present proceedings.
Much obliged.
I'm putting this back. Can I have a copy of this? Just let it be here, the judgment copy.
Very well, madam.
Because there was an earlier judgment of the Kerala High Court which went the other way.
Yes, madam.
So that much I know, but I don't know the rest. So if you can just give me a copy.
Yeah, what's your-
No, he can just xerox करके एक मुझे दे दीजिएगा. Fine.
Keep that, madam.
And let it be on the records.
Otherwise, I have an extra copy.
in the table minutes.
And
Thank you.
By
4 weeks. 4 weeks. 4 weeks. About 4 weeks. लेके जाना है. 4 weeks.
much obliged.
For admission, item number 1.
Yes, madam.
Yes, Your Lordship, I am yet to receive the vetting, Your Lordship. Last night also I called and they say they will, it's already been signed, so they will send through a special messenger, Your Lordship, by Wednesday.
Where is it coming from?
Dimapur, Your Lordship.
You are for the state.
Yeah.
Who is for the central government?
Lordship.
You are appearing. What is your stand?
Lordship, I'm appearing for my senior. I'm not conversing with the madam.
Petitioner is not here.
For the petitioner, Lordship.
You are for the petitioner. Who is appearing for the central? Central government is not a party here.
Lordship, I am for respondent number 1.
Okay, what is your stand?
Lordship, this is with regard to the
See, this matter has reached its finality here.
Lordship.
For this amount that has been quantified, why is it not being paid? You are here before this court. You are for the Union of India, you are for the petitioner.
Lordship, I am for respondent number 1.
Oh, you are for respondent. You are for the President of India. You have not received any amount, Mr. Counsel.
Lordship.
You have not received any amount till now.
No, not yet, Lordship, not yet. Not yet.
Have you filed your affidavit here? Respondent number 1 has filed his affidavit.
Yes, Lordship.
And you have not filed any reply to that. Ms. Livika, government advocate, submits that the affidavit on behalf of the respondent number 2 and 3 shall be filed without fail by Friday. Full stop. A copy of such affidavit furnished to the learned counsel for the petitioner as well as the learned counsel for the respondent number 1. Registry to list this matter. You have a calendar here somewhere? Oh. On 8/12/2025. First of all, petitioner and the respondent number 1 are at liberty to bring on record further pleadings, if so mandated, before the next date of listing. First of all, an endeavor would be made to dispose of this matter on the next date of listing. Fine. Mr. Ahmed, fine?
Lordship.
Lady is suffering. This is not, husband is already gone. There is a limit.
Yes.
And there are directions passed by this court also. Yes.
Deeply obliged. For admission, item number 2.
Your Lordship, here also, maybe the vetting will come tomorrow, Your Lordship. There was some correction and the correction was done, so.
So find your reply against the private respondents.
Yes, Lord, I'm waiting for the.
Government.
Yes, Lord.
Ms. Levika, learned government advocate, submits that the affidavit in the matter on behalf of the respondents represented by her would be filed by Friday, date period. Learned counsel for the petitioner submits that on filing of the affidavit by the state respondents, he would file his rejoinder, if so advised, against the affidavit filed by the state respondent as well as the private respondent. Accordingly, registry to list this matter after the ensuing winter vacations.
Much
Right.
obliged.
For admission, item number 7.
Yes, Mr. Fote.
Maybe Lordship.
Hmm.
Lordship, I ordered it 7/8/2025, passed by this logo. Lordship, state respondent were permitted to conduct an verification about the land ownership. 7/8/2025.
The verification report has not come.
It's not coming.
Yes.
Lordship, I have sent for vetting. But if sometime we required to file for.
File an affidavit. Yes, you are for?
For a private respondent, 4.
Hmm.
I'm yet to file my counter affidavit.
You better.
Lordship.
You better. How were you selected?
On landowner basis,
Huh?
landowner.
You are also a landowner,
I'm
but you were initially not appointed as a landowner. You were regularized as a landowner. Initial appointment, there is no reference to being a landowner.
yeah, usually in the appointment, the landowner appointment,
But the process, why were you appointed as a casual then, on temporary basis, not on a regular basis?
initially they are appointed on probation.
Learned counsel for the respondent submits that the affidavit on behalf of the respondents represented by each of them would be filed. Namlikhiti Bandituta would be filed by when?
1 week.
Give me a date. I'm not with this 2 weeks thing. Give me a date so that I can bind you down. So, on or before 4/12/2025, registry to list this matter again after the vacations then? Nine, okay, 9/12/2025. Okay, file your affidavit.
For admission, item number 8.
My pleasure, Lordship.
30 years,
Lordship,
no pension.
Lordship, I'm seeking for service regulation, Your Lordship. And
Yes, madam, what do you say?
Yes, the petitioner will be considered as part of his period dated 17 March 2015, Lordship. The petitioner guest will be considered as part of his period dated 17 March 2015.
When, by when?
Lordship, it's a very lengthy process to give a record
Yeah,
to the
fine.
person, so
Yeah. Are you saying making the submission on basis of instructions received?
I've already filed my affidavit, Lordship.
Where?
Yesterday I filed that.
Okay, what is the short stand in the affidavit? Affidavit has not come on record. Can you call for that? No, no, let him call for that. So you have agreed that you will consider his case.
Lordship,
We'll dispose it of on that lines. Let the affidavit come, we'll take it up after some time. Give us a requisition slip for that affidavit. Get a requisition slip for that affidavit and then call it. 2 o'clock you can take it up. We'll take it up at 2. So that is your Christmas gift.
Lordship.
Not from me, from the respondents.
Pleasure.
For admission, item number 17.
Your Lordship, here's a similar matter, Your Lordship. Yesterday, Your Lordship instructed me to prepare details of the petitioner details showing.
But all said and done, what about the petition number 1?
Lordship,
She does not have 30 years.
No, Lordship, I'm entitled to please. At column 4, date of completion of 30 years, Lordship.
All of them have retired. Only petitioner number 4 is left.
4, 6, and 7.
Madam, what do you say?
Lordship, here, petition number 2, 3, 4, 5, and 6, Lordship. It's under process, Lordship. But then for petition number 1 and 7, Lordship. Here, petition number 1, he has served for only 26 years, Lordship. And petition number 7 for only 29 years, Lordship. So
They are not covered by.
they're not covered by the OM.
See, there is a decision of a division bench of this court also,
Lordship.
which says that if you have not completed the term as per the government stipulation, you're not entitled.
Yes, Lordship.
Justice Suban Shyam and Justice Debashish Burwa.
Yes, Lordship. Control, Lordship.
So if that be so, how can we pass an order with regard to 1 and not 7, 7, 1 and 7? Because 1 and 7 have not, one has not matured. 7 there is time, but with regard to 2, 3, 4, 5 and 6, what about 8?
And 8 as well, Lordship.
8 as well is under consideration.
Yes, Lordship.
Your Lordship, if I may, Lordship. Time may be granted so that I can take instruction from the petitioner, and if needed, I'll withdraw the name of the petitioners as per the instruction if.
Okay, Lekha. I will not do that. You get your instructions. Now that madam has said that it is under process, we will direct them to give us a status update on the next date. In the meantime, you withdraw the names of 1 and 7, and 1 and 7 file separate petitions. Lekha, Ms. So-and-so, learned. government advocate on instructions have submitted that the cases of the petitioners number 2, Madam, 2,
3,
3,
4, 5,
4, 5,
6, and 8.
6 and 8 have already been processed in terms of the policy of the government of Nagaland for regularization of their services, and the proposal is pending final consideration by the competent authority. She submits that on the next date of listing, she shall apprise this court with regard to the status pertaining to the proposal for regularization of the services of the petitioners. Subpara. With regard to the petitioner number 1, the learned government advocate has submitted that she, having retired from her services with effect from 31/10/2024 and having not completed 30 years of service, her case for regularization would not be covered by the policy of the government of Nagaland. As regards the case of the petitioner number 7, she submits that he is yet to complete the period of 30 years and accordingly, his case is not ripe for consideration for regularization of his services. In view of the above stand of the learned government advocate, the learned counsel for the petitioner submits that on the next date of listing, he shall receive instructions as to whether the petitioner number 1 and petitioner number 8 would be required to be continued as petitioners in the present writ petition. Accordingly, registry to list this matter, we'll have it in January. January. Give me a date, any date, after it opens up.
On 15th?
On 15th is the opening day.
On
Give it-
23rd, on 23rd, Lordship.
23/1/2025, on which day Ms. So-and-so, government advocate, shall place on record instructions received in writing from the competent authority with regard to the pending proposal for regularization of the services of the petitioners number 2, 3, 4, 5, 6, and 8.
Obliged, Lordship.
I'm keeping it in the file. It will be helpful. Affidavit of come.
Lordship, in your affidavit, paragraph 4, page 4, relevant part of your affidavit.
See, we dispose this off with the language that is used in the affidavit. We don't know how long it will take. Lakha. The Miss So-and-so, learned government advocate, नाम थोड़ा सा दे दीजिएगा मैडम लोग का यहाँ पे. Learned government advocate, by referring to the affidavit filed on behalf of the respondents represented by her, has submitted that the case of the petitioner is presently under consideration for regularization of his services. It is further submitted that a proposal in this connection has already been forwarded to the government on 7/3/2024 and therein and in the list of the persons whose cases are contained in the said proposal, name of the petitioner figures at serial number 13. She submits that the said process is said proposal is under consideration and would be finalized after verifying the service particulars and the documents of the persons involved, including the petitioner. So, Subpara, in view of the such stand taken by the respondents in the matter, comma, this court is of the view that the respondents are to be given further time to to take the proposal involved to its logical conclusion. So accordingly, registry to list this matter again on 23/1/2025. First, on the next date of listing, Ms. Namtuteon Namtulibar shall place on record a written instruction received from the competent authority of the department, highlighting the stage at which the proposal is currently pending. Proposal for regularization of the services of the petitioner and other similarly situated person is presently pending. Otherwise, you will have to come back with a contempt. Why poor people? We'll consider it finally.
For admission, item numbers 18 to 22.
Right.
My lord, please.
Yes.
My lord, allow me to just lay bare the facts of the case before I take my to the next years. My lord, the brief facts of the case is that the petitioners are temporary ordinary grade warders. Temporary ordinary grade warders.
Great.
Grade. Yes.
What's the spelling?
GRADE.
Worker.
Warders.
Warders, okay.
Yes, warders. Jail warders they are.
What do you call it? Temporary?
Temporary ordinary grade warders.
Jail warders.
Yes, Lordship.
Okay.
Now, they are appointed under Rule 177 of Assam Jail Rule, which empowers the superintendent of prisons to appoint temporary warders on urgency and on administrative exigencies. Now, the duties assigned to the petitioners who are all DOGs are custodial duties, majority custodial duty, which is the primary duty of a warder. Custodial duty, water carriers, drivers, computer operators.
Water carriers.
Water carriers, cook.
You also have a computer thing.
Yes, Lordship. Those are also assigned to us, Lordship.
And this is assigned to the regular ones also.
Yes.
Yes.
Now, as specific to just assist this court, as specific trade-wise category of temporary ordinary grade warders, their duties, I've annexed in Annexure F, page 198. This was furnished by the department through an RTI.
198.
198, number 2. They are assigned as duties, and specific to their duties, they are given time to time specific trainings as per their vocation.
Hmm.
Now, my lord, let me take me to Annexure C.
And these are
These are,
this temporary ordinary jail warders. They are engaged in the central jails and other sub jails in all over the state.
yes, there are, my lord, just to give a brief statistics, there are 13 prisons in the state of Nagaland, including prison headquarters.
Okay.
And the sanction approved TOGs is 804. As per the administrative approval, lordship, in 2021, there was an administrative approval.
So you have a post of, you have a sanction strength, a sanction granted by the state
Yes.
to engage 800.
And 4. That is a sanction approval, administrative approval. Annexure C, page 196, madam. 196, Annexure C.
$344 sanction posts.
Yes. That is the regular sanction post of warders, 344.
Okay.
Now, my lord, out of this 804.
What is the sanction post termed as, named? What is the name of the sanction post?
Warders.
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 This is in the lower category of that jail administration.
Yes, they are grade 4, lordship.
Grade 4.
Yes.
Okay.
Now, my lord, out of that 804 administrative approval section of TOGs, now presently 784 has been engaged. Out of this, 694 are before this honorable court in this batch of writ petition submission.
Presently, how many? 784 are working.
Yes. 784.
How many are there before me?
694 are before this honorable court in this 5 batch of writ petitions.
Okay.
Now, first, they are appointed under Rule 177, and subsequently there is an administrative approval of sanctioning utilization of their services as per Annexure C. And now, my lord, allow me to take you to page 201. This is a difference in their scale of pay. My lord, the nature of duties, responsibility, everything are not just identical, but are the same. But the only difference is their pay scale. Now they are paid as per, the regular warders are paid as per ROP 2017. And the petitioners are being paid as per ROP 1999. That is the only difference.
ROP 2017 and you are?
1999 ROP. In between also there has been a subsequent ROP as well, but the base structure of the petitioners have been fixed way back in 1999.
When were you recruited, all those people? the time gap, say from which year to which year?
Yes, my lord. 2001. 2022, somewhere also appointed in 2022.
Okay.
Now,
Now, what is your prayers here?
yes, my lord.
What is the relief you seek?
The relief is pay parity as per Jagjit Singh. And if that is with regard to the pay parity. Second issue that I've raised here with regard to regularization. There's been a
Are you serious about the second issue?
yes, my lord. I want to press, my lord.
So let us first take up your pay parity.
Yes,
Now, show me from your pleadings
yes.
what you have pleaded with regard to the,
Pay parity.
no, with regard to the nature of works discharged by you and the regular waters.
Okay, my lord. Paragraph number 6 of my petition.
Because that is the determination this court has to make.
Yes, absolutely. 6, 7. my lord.
So these are the two paragraphs only.
Yes. And I have submissions on.
No, submissions would come, but the pleadings are limited to these two paragraphs.
My lord, if I may take to annexure C again, my lord, just to point out with regard to how the
Page?
service 196, my lord. Just the second paragraph, my lord. Furthermore, in regard to the creation of posts for Longling Jail, Longlang, for the district of Longlang, you are requested to utilize the services of the DOGs. So now it is also, here we can also, this is an indication that the services of the DOGs are the same as that of the watersmen. It is an admitted fact. And even in their affidavit in opposition also, they have not disputed. In fact, they have stated at paragraph number 5 of their affidavit in opposition.
We'll come to that. We'll come to
That
that.
is situated.
Yes. Now, these two paragraphs, how have they been dealt with in the affidavit?
Now, in the affidavit in opposition, paragraph number
Where is your statement pertaining to Annexure C in your petition?
Paragraph 4.
Okay.
Paragraph 7 of the affidavit in opposition.
Affidavit
By the government, state government, there's has always only been.
Abhijit Sinha. The deponent is Abhijit Sinha,
Yes,
right?
yes.
Para 7.
the Home Commission. If I,
That is with regard to regularization.
paragraph
No.
number 6, my lord.
Six.
May I read, my lord?
Hmm.
Here, that in regard to the statements made at paragraph 7, 13, 15, and 17 of the writ petition, the answering deponent begs to state that in response to the assertions made in paragraph 7 of the writ petition, as the name indicates, the terms of temporary ordinary grade waters appointed for a term of 1 year and regular waters are different, and consequently they enjoy different base structure and service conditions. There is no provision to grant parity. This is one of the ground. The answering deponent begs to state that the nature of post of the temporary ordinary water by itself temporary, whereas the nature of appointment, educational qualification of the regular waters are regulated by the rules. Besides, it is irrelevant. It is relevant to state that the government of Nagaland has not taken any policy decision to accommodate the temporary ordinary grade waters as regular water of the jail. The answering deponent further begs to state that the claim of the petitioners is misconceived inasmuch as the question of unequal treatment does not arise in the instant case for the reason that the principle of equal pay for equal work cannot be claimed solely on the basis of similarly situated warders in the same jail under the same department. This is an admission, my lord. Similarly situated warders. It is also an admitted fact by the state respondents that we are similarly situated. It was well settled that the doctrine of equal pay for equal work could not be invoked when employees were similarly circumstanced in every way. The mere similarity of designation or similarity or quantum of work was not determinative of equality in the matter of pay scales. It may be pertinent to point it out that the petitioners were appointed on exigency and their appointment can never be equated with the regular waters. And as such, in the instant case, the unequal or different treatment cannot be treated as arbitrary in terms of different footings of their appointment. All of this is squarely answered by Jagdip Singh as well as subsequently by Shankar Dubey, that temporary warders, if they are temporary employees, if their function and nature of duty is identical, is similar, they cannot be denied equal pay. In fact, the reliability, responsibility, and the confidentiality of the services.
No, what is the qualification for a regular warder?
8 plus 8. And the petitioners have it. I did it in my petition also.
Have you filed a reply to this?
Yes, madam.
This is the only affidavit, I suppose.
Yes.
How have you dealt with para 8? Somewhere you have said, I'm not finding it today, that you are work in rotation basis.
Yes, madam.
Where is
Yes,
that?
it is. It is said. Paragraph number 6 of my affidavit in reply. I have annexed the roosters. May I read my?
That's right.
My lord, my reply to that is at paragraph number 4. With regard to qualifications also, I have replied. That with regard to the statement made at paragraph number 6 of the affidavit in opposition, the deponents state that it has been ruled in a plethora of cases by the Honorable Supreme Court that the nature of appointment of the subject post is inconsequential while granting pay parity. The only determinant as to the grant of pay parity is whether the concerned employees were rendering similar duties and responsibilities as were being discharged by regular employees. In the instant petition, it is apparent on the face of record that the state respondents have been deputing the DOGs to discharge duties and responsibilities which are assigned to regular employees, which has not been denied.
Yes. What is the decision you want to rely upon?
Just 3 chronological cases from Bhagwan Das. I want to rely on Bhagwan Das Jagjit Singh and Shankar Dubey.
Shankar Dubey,
Yes.
Forest.
Yes. And I have a few from this coordinate bench.
Hmm. Just mark it serially 1, 2, 3, 4. Mark it serially 1, 2, 3, 4. How you want to place it.
Now this first case, my lord.
Hmm.
The state went against the division bench order. The state went for appeal in the file in SLP in the Supreme Court. And this year on 28/5/2025, the appeal was dismissed. So the division bench order post appeal. That gifting is relied upon.
Hmm. Let us have WA 9. That is.
Yes. Para 18 and 19.
This again is pertaining to parity. Right?
Yes. But I need to, my lord.
Parity of pay.
Yes.
Minimum Jagjit Singh.
Yes.
That was upheld.
Yes.
Then writ appeal 29.
2024. This was with regard to the sweeper.
Sweepers, and that has been considered
Yes.
by the single bench in WPC 54 of 20, right?
Yes, my lord.
So this is a settled proposition.
Yes. It's clear. May I give the citation for the Bhagwantas, Jagjit Singh and Shankar Dubey?
Just give me Bhagwandas. What do you want to emphasize from Bhagwandas?
That the emphasis in these three cases is that
Bhagwandas is not a case for the proposition that a temporary worker would have. Just show me Bhagwandas.
1987 for SEC 634.
87.
For SEC 634. Para 11, my lord.
This has been now taken forward in the
Yes.
Jagjit Singh and
Jagjit Singh also, yes.
Fine.
And Jagjit Singh and Shankar Dubey.
Okay. So this thus your parity part.
Yeah, with parity.
Now regularization. Your case basically is that earlier they had made a seniority list and some persons were regularized. But how do you put your prayer in the context of the policy of the state, 17-3-2015, 30 years, as well as the interpretation thereon by this court?
Yes, my lord, there is a peculiarity in the way we are being appointed. Second,
How are you appointed?
there's no provision as such that regulates the appointment of or utilization of the services of DOJs, except as some jail rule.
No, how were you regulated? How were you appointed? Where was there an advertisement wherein you were asked to apply? Then your suitability was judged by a committee constituted. And thereafter, a merit list was published. And from there you were appointed, albeit on temporary basis. Were you appointed in that manner?
No, it isn't.
You never sat in an AC room?
No, it was only limited to that.
No, you never sat in an AC room. You walked from the road, from the footpath straight to your post. You didn't go through a AC room. AC room means a selection. So,
Yes. For that.
and with this 2001 recruitment, say another 24 years,
Yes.
wherein there are hordes, lakhs, thousands
Yes.
waiting
Yes.
who have already completed 30 years.
Yes.
They have not been given. We can make at best a wishful thinking in the order to the effect that whenever your case falls within the parameters of the policy of the state, your case will be considered.
That can be an option, but allow me to just.
That's what I want you to take me out of this. That's why I told you.
Just to make an endeavor to
Please.
get it out of.
I want you that. I want you
Yes.
to do that.
First.
You need not go around anywhere. Come to the point.
First, rightly or wrongly, they have been appointed under section 177 of the SMJ. And the fact remains that.
Show me the provisions of 177.
Page 2. Mary. Superintendent's power in emergencies. Where the superintendent considers that it is necessary for any reason to entertain any number of orders in excess of the sanctioned scale, and the matter is so urgent that the previous sanction of the Inspector General cannot be obtained, he may, subject to immediate reference to the Inspector General, entertain such number of temporary ordinary grade orders as may be necessary. Now the provision is clear that it is only for emergency and urgency. It is only for a specific period of time. However, my lord, the way the state respondents have been utilizing the services, which is akin to the regular waters. Now, the continuous and substantive nature of
perennial nature.
Yes, perennial nature. That I want to come to that. Perennial nature has evolved quite substantially, and then there the Supreme Court has now accepted.
Jago.
Yes.
Jago.
Yes, Jagu from Shripal, Jagu, and recently Dharam Singh.
But there are two decisions of mine sitting in the division bench.
Yes, ma'am.
Mr. Bora will know, where I have distinguished Jago in the context of that case. What happened to the Supreme Court matter? That IIT, ITI, engineering colleges.
Supreme Court, the matter is pending. However, Supreme Court has fixed it for an interim order by wherein it says that it has called for the vacancies which is left, so that it can pass some interim order to that effect that a limited examination can be held
For
among
them,
for them. And
and then proceeding.
yes,
The orders have not been passed.
the state has not given the vacancies yet. It was listed on 31st October.
Great. Thank you. See, when we pass that order, say a person who got recruited in 2022, he is also to be regularized. Now your petitioners are not of a particular time. They are of a lengthened time. So when I pass an order, I'll be passing this order covering 2001 appointee as well as the 2022 appointee. I cannot make a distinction here.
My lord, let me come to that. Before I continue, the prayer made before the Honorable Court is not a bare plea for regularization for all the adversary, for all the petitioners. No, my lord. There has been a convention or there has been a norm in the department that whenever there is a vacancy, say for instance, if there is 5 vacancies in a calendar year, 1 will be given as per the seniority or.
Where is that policy decision of the government to that effect?
There is no policy decision. That is
So some superintendent, now this exercise would be done
Yes.
by whom? By whom? Who will do this exercise?
by the state, by the department.
By the department, not by the superintendent.
Yes. So that is
Who
why.
will do it?
Yes, that is why, my lord, we have come before this honorable court, not to give a direction.
That
to
direction I
regularize
can't
us,
give
but
also.
Come up with a policy. so
That
there
direction,
can be some.
that direction you will get once you cross me, once you cross the division bench and then go before the Supreme Court. Supreme Court can 141, it can pass that order. But we don't have that power.
My lord, the jurisdiction under two.
And I, Mr. Counsel,
Yes.
just sorry I'm interrupting you. I cannot frame a screen.
Yes.
I cannot lay down the manner in which the regularization is to be done.
That, my lord, that is there.
Then now go ahead. Now convince me.
Now, my first point to that is continuous and substantive.
Perennial.
Yes, perennial. And if it's apparent that the nature of their appointment, the nature of their work is not sporadic in any way of the matter. It's not sporadic. Second, my lord, the nature of duties is exactly the same, custodial duty, and in fact, everything from custodial duty to the.
That because in the parity of pay, you have established that.
Yes, yes, yes.
We're not going to that.
Yes.
But tell me how the regularization. And regularization for all the petitions. They are here together.
Yes, my lord. Regularization for it, let me put it this way, my lord. Regularization for those petitioners who have substantially served the department for.
What would be that substantial?
Yes, my lord, that direction, that liberty can be granted to the state government to make.
I grant them. I grant them.
Yes.
They will come back and say it's 30 years in the state. We have not challenged that 17/3/2015 and the subsequent memorandums. And there is a decision of this court division bench on that point against you. Justice Suman Shyam and Justice Borua, writ appeal. Exactly the same issue was considered. Forgotten. I read somewhere.
Now, my lord, our category, we are not exactly as work charged.
You are same. You are just, see, work charge is different. It's an asset. You are, when you were born, you were only for a temporary period.
Yes.
And if I now direct that all these people should be regularized, what would happen to the unemployed youths outside, waiting for an opportunity, a government job?
No, my lord, we are also not.
You are privileged that you were picked up. Please don't mind using my words, just to get the message across.
Yes.
You were picked up. I put it in a more refined sense that you never was required to sit in a AC room before you were offered an appointment. So participate if there is a need of, if they have a need for more posts of warders, we can require them to examine that. Create posts, apply. You get a advantage we give you, considering your period of service you have rendered, you are entitled to a certain percentage of marks. And that is permissible under law. We have the earliest judgment would be by my Lord Justice Ranjan Gogoi when he was the judge with regard to bungalow peons, High Court. Then that was again given in this casual, then that give them some benefit. Not exactly a preference, but a better preferential treatment. So you start with an advantage of 5 to 10 marks in this selection process.
I not hear the position. The position is that whenever vacancy arises, direct recruitments are also being done. It is just that
I can only, the way you have beautifully put it, I can only do one thing, require them to prepare or require them to consider a scheme, preparation of a modality,
yes,
so as to address your discrepancies. More than that, at least this court will not do. I'm waiting for that order. Supreme Court, let's see how it goes. Jaggu, fine, very good.
yes.
But see, we have our limitations. That power is with the Supreme Court. The Supreme Court can pass that orders. But mind you, Uma Devi is of a larger bench and it's still holding the field. Other than para 53 thereof.
The conditional regularization for irregular appointments.
Irregular appointment. You are a total illegal appointment because anything. 48, 49, if you read that, what is illegal, what is irregular? Here, if I go deep, scratch, nothing. There were someone, you knew, you came in. But the other person did not know, he could not, or he would have been there, not you. Parity, I am with you. Until and unless he does not bring in a nuclear bomb, I am with you.
My lord, if I may just take you to one annexure.
Yes.
One annexure. Page number 202.
20?
202.
202.
Mm. 230, my lord, 230, annexure J. This is a communication by the Director General of Prisons to the Home Commissioner. Mary, my lord.
No, this is a proposal.
Yes, this is not yet a decision, still not.
That
it's not
decision
yet-
is at the liberty of the
Yes.
government.
Yes, yes,
So government has already a cabinet decision leading to 17/3/2015 and the other circulars thereunder. We'll note that, we'll ask them, but we will give you a pay commensurating to your job. That much I can do.
if I would just substantiate a little bit my submission. Already is very well aware that perpetuity in whether in ad hoc or temporary capacity.
P.R.R. Singh. But P.R.R. Singh is gone now. It's like those trendy clothes, designs, you find them coming back now. So we may have the flavor of Pyara Singh again back now. And those judgments we had at that point of time. Anyway, what is the decision you want to rely upon? Perennial is your main submission. Okay, we'll consider. How long have you been practicing?
8 years now.
Good. This is the persuasiveness I like. Yes.
2024 9 SEC 327 Vinod Kumar Manor. Pair 5 and 8. And
987. Vinod Kumar is 2024 9 SSC
327.
327. Para? Para?
2024
Para?
pair 5 and 8 Manor. 2024 SEC online SC 3826 Jago versus Union of India. May I take the para?
No, it's okay. Para? Which para you want to rely?
11, 12, 13, 16 almost all mine.
Okay, fine. Then
Next 2025 SEC online SC 1735 Dharam Singh Manor.
16. Para?
1735 Manor.
Para?
Manor.
Just give a compilation. Just give it together. One para?
Para 7, 9, 11.
This was a decision by my Lord Justice Bikramnath.
Yes, Vikramnath and Justice Sandeep Mehta.
Matter. Yes.
9, 11, 15, 17, 18, 19.
Okay, fine. Everything. Then
2025 SEC online SC 221. Shripal and another versus.
para?
A moment, my lord.
See, these decisions have come. There is a in between 2-page decision of the Supreme Court.
Yes.
Totally contrary to this.
Yes, my lord.
I think I've referred to that in that judgment. There is a judgment of the Supreme Court totally contrary to this proposition in Jago, Dharam Singh and all, which says no.
Pass which this year.
25 itself.
Right. I will.
Anyway, okay, then.
Then just last supplementary point on legitimate expectation. I want to just cite one citation 224 2024 3 SEC 799. Sivanandan CT versus High Court of Kerala. Para 18, my lord.
You read it.
If I may just read it, my lord.
No, you read, just read. No problem. Read slowly. Para 18.
Para 18, my lord. Just a moment, my lord.
No, it's okay. It's okay. Take your time. Excuse me. Only these 3 pages. Huh? These 3 pages. Xerox, put it inside. This is that matrimony. Hey, Govind, WA number 49/2025. Duta decision ase ekalage.
2024 trees.
49/2025. Tar logot aru eta ase, duta ase. 48 asil no 40/50 hobo. 49/50. One was 49 and another was 50. 50,
Yes.
50. Copy to Tau Light was.
Married, my
Yes.
lord.
Yes.
The basis of the doctrine of legitimate expectation in public law is founded on a principle of fairness, non-arbitrariness in government dealings with individuals. It recognizes that a public authority promises or past conduct will give rise to a legitimate expectation. The doctrine is premised on the notion that the public authorities, while performing the public duties, ought to honor their promises or past practices. The legitimacy of an expectation can be inferred if it is rooted in law, custom, or established procedure.
So you mean to say that the earlier process of regularization
Yes.
of your seniors
Yes.
has given rise to a legitimate expectation on your part? And considering the perennial nature of the job
Yes.
that you are rendering,
Yes, my lord.
you say your case is covered by the decision of Sivananda. That's
Yes. My lord, I'm also asserting a discrimination also on in that line.
how.
They have been regularized. Even
Are they juniors to you?
some of them serve even lesser than us, but
Why have you not challenged their such regularization?
my lord, if we challenge that,
No, I'm saying only to the extent of juniors being regularized, not the seniors.
no, not in that way, my lord, not juniors to us in the seniority list. They were seniors to us, but then their length of service.
How they are senior to you in the seniority list, but length of service wise, they are junior to you?
No, my lord, my point is, those who were appointed ahead of us way back in 2015, 16, 17, 19 till 2020, I have placed on record the list. Some of them were, by virtue of them being senior, they were regularized. 1 or 2 of them were regularized. But for us now, after 2020, there's not been any regularization as such given to us.
But you by now have
I have
discharged
now.
duties,
Yes.
length of service, length
Longer than
of.
that.
I
Now,
was shocked.
yes, serial number 1 in the seniority list has served for 24 years now, my lord.
Okay. Anything more? Anything more?
Yes, just one
Yes.
statement that was made in the affidavit in opposition of the government. Para 7, my lord.
To the effect?
To the effect that they have said, since the government by office memorandum parent number such and such dated April 2020, there has been an embargo, there has been a freezing. It was during this COVID pandemic, my lord. The state government throughout the state in all the departments.
But now they are doing it. They are doing.
Yes, that has been by a consequent in 2020, which I've annexed in my affidavit in reply. They has lifted the ban. But in their affidavit in para number 7, because of that, the language here, my lord, thereby the regularization of POGs in the jail department has been already suspended.
Fine. Done. Good. This is how you argue. I liked it. You get a relief or not, that's a secondary issue. Otherwise, I'm a very impatient man. I don't listen for such a long time.
Yes, my lord. I'm grateful.
Lekha. Heard Mr. So-and-so at some length. Mr. Heard Mr. So-and, learned counsel for the petitioners in the above noted writ petition. Mr. has completed his submissions. So, Mr. Government Advocate, huh?
Yes, ma'am.
Submits that he would make his submissions on Thursday. So, registry to list these matters again on Thursday. Date to deliver as a part heard.
May I please, Lordship, sorry for, I didn't my apology, my lord. Last week, the file was handed to me, but till Friday, I was on leave. I could collect the file only yesterday. So that is why I'm not ready. I'm sorry for that. I could not help your Lordship, my lord.
Are you busy?
Yes, my lord.
Thursday, no
Yes,
problem,
yes.
no issue. These are not big things.
Much obliged.
Thursday.
Much obliged.
And council, keep up your readings.
Thank you, Manoj.
Next time, we will see you a notch higher.
Thank you, Manoj. For orders, item number 9.
Worship. Just to save time, I will be allowed to file affidavit in opposition on
Item.
Friday.
What happened after this judgment passed by Justice Marley Vanku? After that, Jamisab, this was taken up on appeal, no?
No, Lord. Actually, what happened was, judgment was on 26/9/2023. Just the next day, the advertisement came out.
It will be hit because that law is already settled. So one day afterwards, that would be the law
Yes.
on the date of the advertisement. Okay, a senior is asking for accommodation. We'll provide him an accommodation till Friday.
By Friday.
But we'll have this matter again on Wednesday. Will it be convenient, Mr. Sohams? Mr. submits that government advocate submits that an affidavit would be filed by the respondents represented by him without fail on Friday. Oh, this was the last chance one. Oh. Come on. How do I get over with this last chance? Give me an idea.
Lordship, last chance, I agreed, but Honorable Court has discretion power.
No, I don't have. I'm bound by this. So I'll work a way out. You have a bar association here? You have a fund?
Yes.
Heard Mr. So-and-so, learned counsel for the respondents. Mr. So-and-so submits that the affidavit on behalf of the respondents represented by him is ready. However, the same could not be filed. First off, in terms of the directions passed by this court, wide order dated 10/11/2025. Mr. C.T. Jamil, learned counsel for the petitioner, submits that this court had granted a last chance to the respondents to file their affidavit in the matter. Wide the order dated 10/11/2025. This court has perused the order dated 10/11/2025 and finds that on the prayer made by the learned counsel representing the respondents, as a last chance, 2 weeks further time was granted by this court. The affidavit, however, is not filed. The learned counsel appearing for the respondents have submitted that he be granted further time till Friday to file the affidavit on behalf of the respondents represented by him. First off, although the prayer is objected to by Mr. C.T. Jamil, learned senior counsel appearing for the petitioner, this court, for the ends of justice, permits the petitioners to state respondents to bring on record their stand by way of filing an affidavit by Friday, subject to payment of a cost of rupees 1,500. First off, the cost be deposited with the registry of this court. The registry being on the cost being deposited shall forward the same to the, how do I?
Bar Association.
High Court Bar Association for utilization of the same in their activities.
I have to pay.
Yes. Not you, government.
No, I have to. Because
Okay, 1,000.
because the
Otherwise I
they
can't.
furnish me.
I
with lot
can't.
of-
Otherwise I can't. It doesn't look nice. Now I have imposed the cost so I can open that order. And it will come back to you only, I could. Or if you want to increase it, I can do that. See, by status, I think it should be 10,000 for the bar. Now that you are paying, I'll put it 10,000.
Yeah, it will come to our account only.
I'm sorry, but we'll have to work out something. Yes.
For orders, item number 10.
Lordship, as per the last order, service upon the private respondents was still available, Lordship.
Who is appearing for the prayer? You're appearing 6 and 8.
Lordship, I have instruction to appear for respondent number 8.
8. Not filed your wakalatnama.
Not yet.
Affidavits have also not been filed. The whole tender process is under stay. If you say if you're not interested, we'll quash the tender process then. And we'll ask you to go afresh. You don't seem to be interested.
Allow me some days, Your Lordship.
No problem, but this work is hindered. Work is not being taken forward because of your action in selectively permitting tenderers to. So if that is correct, we'll quash the tender and give you liberty to proceed with the fresh tender process. Have your instructions. The learned senior government advocate appearing for the state respondents, as well as Mr. Namtulina, just take them. Appearing for the respondent number 8 submits that the affidavits on behalf of the respondents represented by them would be filed on or before 4/12/2025. Registered to list this matter again on 8/12/2025.
Let the interim continue, madam.
Interim order passed earlier to continue till the next date of listing.
Deeply objective.
For orders, item number 23.
Mr. Jamie, any objection for substitution?
No.
Will substitute it. But Mr. So learned counsel appearing for the applicant. Also heard Mr. C.T. Zamir. You are appearing for Mr. Zamir? You will be appearing for? For the opposite parties, 2 and 3. While Mr. ऊपर में उनका नाम लिखें, respond number 1, circle. 2, 3, learned C.T. Zamir, senior counsel. 4?
2 and 3.
And who is for 4?
4 is the village council.
4, we took steps by.
None has appeared for respond number 4. Full stop. The present interlocutory application has been instituted by the applicant oblique petitioners, by the applicants oblique petitioners, praying for permission to substitute the original respondent number 2 with his legal heirs. Full stop. I've heard the learned counsel for the parties and also perused the contentions made in the present interlocutory application. Also, as projected in the interlocutory application, respondent number 2, Mr. Kesito Yapto, had passed on 28/9/2025. The said information was not immediately available to the applicants herein, applicants oblique petitioners, and on receipt of the said information, they, after confirming the said fact, had proceeded to institute the present interlocutory application with prayers as noticed here and above. Full stop. The learned counsel for the respondents, the learned counsel for the respondents appearing in the matter have not objected to the prayer made in the present interlocutory application. Accordingly, next time, accordingly, this court permits the substitution of respondent number, original respondent number 2 in the connected writ petition with his legal heirs, that is A to A. Page 6, A2, prayer portion, it's there. 6, as a respondent's number 2 bracketed 1, 2 bracketed Roman 2, 2 bracketed Roman 3, 2 bracketed Roman 4, 2 bracketed Roman 5, and 2 bracketed Roman 6. Right? Roman 6 and Roman 6, 2 bracketed Roman 6. With the above observations and corrections, the present interlocutory application stands disposed of. You now come to the writ petition. In view of the order passed today in IA bracketed C 223 number oblique 2025, substituting the original respondent number 2 herein with his legal heirs as follows. Now that 2.1, 2.2, 2.3, just take it down one by one, put the names against their names. First up, in the following manner. First up, subpara. Petitioner to file an amended cause title, bringing on record the newly impleted legal heirs of respondent number, original respondent number 2. The amended cause title be filed within a period of 2 working days. Registrate to list this. We'll have to issue notice to them now.
Yes.
You are appealing, mister. You will not be appealing for the legal heirs, or notice has to go.
I'm appealing only for respondent number 2 and 3.
True. No, will you be appealing for the two heirs also? Legal heirs of 2. Will you be? You have your instructions. Register to list this matter again on 3rd of December 2025. By the time you get this thing done.
What you do? Obliged.
For hearing, item number 11.
May I please lordship, the petitioner herein is praying for regularization of his service.
2004 appointment.
Yes, his
Now
service.
show me the law or the scheme of the government.
Yes, and there is also a vacancy,
No.
my lord.
How can I help you here? Tell me. Because the law requires, a scheme requires 30 years.
No,
You have around
there's a notification of 2004.
2015, there is a fresh notification.
Yes, my lord, but 2004 is regarding regularization of work church casual employees.
This also is work charge casual employees,
Yes.
2015. That is
So,
the
but-
latest.
But this two.
Madam, that is the latest policy, 2015.
Yes, sir.
That is holding the
But-
field.
My lord, 2015 has not superseded 2004 notification.
Oh, we will deem it. We will deem it superseded. Show me the 2004. Where is it? Page 41.
Yes, my lord.
And where is the 2015 one?
2015, it's not enclosed here, because the petitioner is claiming on the basis of the 2004 memorandum.
That you will get it at page 46, earlier order.
Yes, my lord. Page 41 is the office memorandum of the 22nd September 2004.
How old are you?
Now, my lord, the petitioner is about 40 years.
40 years, another 20 years to go. You will be covered in the meantime.
No, my lord. If lordship has got the annexure M, page 41, regarding the office memorandum of 2004, policy and scheme for realization of work.
Give me 2 minutes. Okay, madam, you have filed an affidavit here. Come to para 4.
Lordship, I will be relying on my additional affidavit, Lordship. Filed on 13th December.
What is this statement made in your affidavit? These are not established. You only put him in probation period for 1 year. I don't know how you have put him. He's neither a regular employee nor a probationer earlier. So he's just a temporary employee. Why probation? Now he has filed a reply and he says that I had some problem, but now I am regularly attending duties. That's your question. But what about para 4, ma'am? You said you undertook there that whenever a vacancy arises, you will be considering his case.
Yes, Lord.
You'll do?
Yes.
You'll pass that order.
Yes, Lord. But as per the procedure,
What is that procedure? You have not spelled out here.
uh, there has
Not
to be,
spelled out in para 4, madam.
yes, Lord, but there has to be a sitting DLRB, Lordship.
DLRB,
Yes, Lord.
say he has only completed 18 years, 19 years, 20 years maybe. Now, with that, in the DLRB, you will consider his case.
His case will be taken up, Lordship.
Madam, be very careful in your statement. He has not completed 30 years. That's your policy.
Yes, Lord.
So here, for him, you're relaxing that.
Since Lordship is the only non-employee at the moment, Lordship.
It will create problems for you. I can pass that order. There is no problem for me.
Well, Lordship, sometime maybe granted to me, Lordship, maybe if this matter can be listed on Friday.
Thursday,
Lordship.
on the prayer of the learned counsel for the petition or respondent, government advocate, on the prayer of the learned government advocate appearing for the respondent, register to list this matter again on Thursday and date. Full stop. The learned government advocate shall receive instructions as to whether the petitioner with the present length of service rendered by him as a work charged contingency fixed pay employee, which is much less than the 30 years mandated. The case of the petitioner shall be considered for regularization in the next meeting of the district level recruitment board bracket DLRB of Mon, which is the village, which is the district?
Longling.
Longley. So, in accordance with the contention made in paragraph 4 of the affidavit filed by the respondents number 1, 2, and 3. Just get a clarification. If it is there, we'll direct what is there.
Yes.
Yes.
Apply, sir.
For hearing, item number 12.
Who is appearing for the respondent, item number 12? Madam, who is appearing for the government in item number 12? It's agriculture. Agriculture.
Lordship, no, they will, Lordship.
They had taken a time. I just wanted a clarification, that's all. This matter will not go otherwise anyway. Remain like this. On the prayer of the Learned Council for the parties, a registry to list this matter after the ensuing winter vacations.
For hearing, item number 13.
Your Lordship, I am appearing for the petitioners in item number 13 and 14. Your Lordship, on the earlier occasions, the State Council had been directed to file a reply. However, that has not been filed yet. And I see no one is appearing today also, Your Lordship.
You continue.
Your Lordship, then I would request a date because I am not under the instruction
On
for
the prayer
hearing.
of the Learned Council for the petitioner, a registry to list this matter again after the ensuing vacations.
Your Lordship, the interim order may be extended.
I'm sorry, this is hearing. We'll hear it today.
Your Lordship, then grant me a pass
That is
over.
what you wanted. That is what you wanted the last occasion. There was a big objection raised. So we are ready.
Your Lordship, actually, we want to be there in person and do the hearing, Your Lordship. Kindly extend the interim order, Your Lordship.
Registry to list this matter again on 4/12/2025. Interim order to continue till the next date of listing.
Grateful, Your Lordship.
The pleadings, if any, be brought on record by the concerned parties on or before the next date of listing.
Grateful, Your Lordship.
14 is also same.
Yes, yes, Your Lordship.
14, 13, 14, huh? दूसरा type of beleg order, 2 orders.
For hearing, item number 15.
Today no work, finished.
Please, Your Lordship. Lordship, kindly accommodate for today, Lordship, as
On the prayer of the Learned Council for the petitioner, a registry to list this matter
after vacation, Lordship.
The man has joined, the other person has joined
Yes, yes.
after the ensuing vacations.
Obliged.
You are going nowhere, ma'am. You are going nowhere.
Lordship, this is where.
You file I'm telling you, file an amending application, bring all those things on record. Go home. Why this? This is not going to take your client anyway. Okay, ma'am.
Obliged.
For hearing, item number 24.
Yes. Now, what is the procedure for challenging in the state a decision of the village council? This is a decision of the village council.
It's a decision of.
No appeals have been provided to the civil courts.
To the deputy commissioner. That is according to the rules. In 1937.
But deputy commissioner now has to be read as the district judge.
No, my lord, no.
Where do I get the rules governing
The,
proceedings?
yes.
Yes. What is the procedure?
It needs to be filed before the deputy commission. Ask for rule.
Rule? Is it a court, Mr. Is the village council a court?
The village council is a court.
Where do I get that?
That rule, your lordship will find that in rule 23. Rule 23 of the rules. Under the heading civil justice. The administration of civil justice in the state of Nagaland is entrusted to the deputy commissioner, additional deputy commissioner, assistant to the deputy commissioner, customary codes constituted under chapter 4A. This we don't have right now.
We don't have do we have a Civil Codes Act or
Not
rules?
yet, man. We follow the Assam Bengal Civil Codes Act. The Bashis and other village authority may be appointed by the state government from time to time by notification in the official gazette. So under this provision, the village council is the customary code at the village level. Then against the decision of the village council, your lordship will see Rule 31. Rule 31. An appeal shall lie from the decision of the Mazadar, Gambara, chief headman of Kher, Dibashis, or other duly recognized village authority to the tribal court whenever constituted or otherwise, to the deputy commissioner or his assistant. So there's no tribal court as of now, your lordship. No deputy commissioner or his assistant.
The earlier provision in administration, sir. But it's not a court. Where is the provision that a village council is a court?
Recently, there has been an amendment that has been clarified.
Can I have that? Because you are seeking my supervisory jurisdiction, I can only extend it to a court under my jurisdiction. A village court, if there is a Civil Codes Act, that is not reflected as a court.
Yes, ma'am.
Then how will I come in?
Customary court, your lordship.
I know that, but
Customary court.
there has to be a connect between any decision that a decision of the village council would be assailable under 227.
We already have a decision on that.
Well, then show me that.
That straight to that point.
That's it. So first, the jurisdiction. Oh, this is too old.
No, but this is the law which is holding the field right now, as far as Nagaland is concerned. This is 1986, 2 GLR 296.
No, when this law was being subject to correction, that time the district judge, the additional district judge was deemed to be a court.
My lord, yes.
So a revision, fine, I can understand. But today, with the separation of the judiciary and the village council, because here I am concerned with the village council. Now, where do I get the law that a decision of the village council, this court has supervisory jurisdiction?
Your lordship, by the very inherent nature of Article 227.
No, Article 227, read Sound 227. Every high court shall have superintendence over all courts and tribunals throughout the territory in relation to which it exercises jurisdiction. Now, whether this is a court.
Village council is it?
Any recent decision on this point?
Yes,
of this court?
There's a recent amendment of 2022 of the Nagaland Village Area Council Act. And this, in fact, recognizes the role played by the village council, then puts it down on paper to pen and paper in black and white. Your lordship can kindly see at page, the second page, amendment of section 14. The village council shall function as village court as envisaged under the rules of administration of justice and police in Nagaland 1937. In accordance with the customary law and usages.
Any appeal against a decision of the village court shall lie with the subordinate district customary court and the district customary court as decided by the area administrative officer or the deputy commissioner. So it provides for an appeal.
But we don't have any district customary court as of now.
Then it will be, in terms of the earlier one, it will be the deputy commissioner.
It will be the deputy commissioner. But your lordship, the decision that I was referring to earlier, which I placed before your lordship, this is the law as far as the
show me the relevant portion.
yes, yes. So this is beginning from Your Lordship, you come to page 299. 299. The Indian Divorce Act was amended in the year 1951, and by the said amendment, the act was made applicable to the whole of India except the state of Jammu and Kashmir. Therefore, Nagaland being a part of India, the Indian Divorce Act is applicable to Nagaland also. The Scheduled District Act 1874, which repealed the Garo Hills Act of 1869, especially confers power on the local government under Section 5 to extend to any of the scheduled districts or to any part of such district, any enactment which is enforced, etc., etc. But the Lordship will come to the middle of the page. It is further submitted that Section 26 of the State of Nagaland Act 1962 clearly provides that all laws enforced in the Naga Hills area shall continue to be enforced in the state of Nagaland until altered, repealed, or amended by a competent legislature or other competent authority. The legislature has not repealed or amended the applicability of the Indian Divorce Act 1869 to the state of Nagaland. Now, this is the argument, Your Lordship. And then we can come to page 304. Page 304. One other submission of the Learned Council is that by virtue of Clause 1 of Article 372 of the Constitution, the customary laws of Nagaland relating to marriage and divorce prior to the commencement of the Constitution continue to be enforced after the commencement of the Constitution until altered or repealed, and therefore the Indian Divorce Act is inapplicable to the state of Nagaland. But Clause 2 of Article 372 of the Constitution of India empowered the President to make by order such adaptation of law which by way of repeal or amendment as may be necessary or expedient for the purpose of bringing the provision of such law into accord with the provisions of the Constitution, and to provide that the law shall, as from such date as may be specified in the order, have effect, subject to the adaptations and modifications so made in exercise of the said power. The President made the adaptation of laws order 1950, which came into force from the 26th of January 1950. After adaptations in Section 2 of the Indian Divorce Act reads as follows. This act extends to the whole of India except Part B states. Section 2, etc. etc. Then the further argument, further discussion at page 305. In the middle of the paragraph, in the middle of the page, the contention of the Learned Council relying upon the provisions of Article 371A of the Constitution, providing that no act of Parliament in respect of Naga customary law and procedure shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decided need not detain us long in view of the express provisions of Section 26 of the State of Nagaland Act 1962. And the further fact that the Indian Divorce Act 1869 is not an act of Parliament to which the provisions of Article 371A of the Constitution are attracted. The Patna High Court in such and such. Then the last paragraph, it is lastly urged that it is the duty of the court when both the party to the litigation are indigenous inhabitants of Naga Hills to make an endeavor in accordance with the letter and spirit of Rule 30 of the Rules for the Administration of Justice and Police in the Naga Hills District to induce them to submit their case to a panchayat. The Learned Council invited our attention to the decisions of the Assam High Court in such and such. And next page, Manoj. In all these cases, the learned judges held that if the parties agreed to go to a panchayat, then the procedure prescribed in Rule 30 should be followed. In this case, the Additional Deputy Commissioner in his order clearly held that when the parties are unwilling to go to the customary courts, the court cannot compel the parties to go to the panchayat. So in my case, Your Lordship, the first point I would like to make is this. The Indian Divorce Act is applicable to the state of Nagaland. The application of the Indian Divorce Act to the state of Nagaland automatically ousts the jurisdiction of the village council. Therefore, the village council has no authority in law to adjudicate the marital dispute between me and the respondent. And on this point, Your Lordship, there is another decision of our Honorable High Court, a recent decision. This is in the case of the Armstrong case. Your Lordship will be aware of that. The IFS officer. IFS officer. This is 2022, 5 GMT 392. So here also, taking into consideration the provisions of the Indian Divorce Act, this Honorable Court came to the conclusion that which court should decide marital disputes is prescribed by the Act, and no other court can take jurisdiction of such issues. And here also, Your Lordship, the village council had dissolved the marriage. That was set aside. And this court came to the conclusion that the village council had got no jurisdiction.
You are the husband.
I'm the wife, ma'am.
The wife. The husband had gone before the
village council. So in this case, in the writ petition here, my lord, I am challenging only the jurisdiction of the village council. I am saying the village council has no jurisdiction to entertain this marital dispute between me, and the respondent.
So basically your cases of jurisdiction.
Yes, my lord. Purely on jurisdiction.
Yes, Mr. Consul, what do you say?
Your Lordship, the human aspect of the case has to be taken into consideration.
Human aspect once we
Now,
understand the law.
Yes, so far as the submissions on the basis of law is concerned, it is very clear after the judgments of this court. But the problem here is, after the judgment was, after the order was passed by the village council, for 8 months, the petitioner was sitting over the matter. Only after the
Order which is void ab initio,
yes, now.
without jurisdiction, a delay can take on.
It has to be challenged.
Have you married
Yes.
again? Have you married?
That is the problem. On December 5th of 2024,
Is there a stay order operating here?
no stay order. It came up, my wedding invite came out, and then seeing that, the
Okay.
petitioner has approached the honorable court now, and she has also.
Okay.
Yes,
How much will you pay her?
Your Lordship, I have, and on the last occasion, unless the petitioner also.
Petitioner will
Yes.
ask subsequent, how much are you?
I am unemployed, I am a contractor. But the.
Contractor.
Your Lordship, I'll take your Lordship to the position of mine.
We can't, we will not, because you are not expected to file a income tax. So we don't know what your income is. How much are you offering? How much are you offering?
On the last occasion, I was, according to my capacity, I was offering, was a one-time settlement, 30 lakhs. And then.
How long were you married?
From.
Children?
Two daughters.
Where are they?
With the mother.
Okay, 30 to the mother. How much to the daughters? Daughters are yours, you are not?
Yes. She has, in fact, the eldest daughter was with me.
No, it's good.
Before any divorce or any separation, she approached the family court for the custody of the daughter. I objected before the family court that there is no divorce at all. It is no.
Now there are three, now there are three. What is the age of the daughters?
6 and 2.
Oh.
6 and 2.
Oh,
Yes.
they will have to be provided something.
Yes, Your Lordship.
Yes, how much are you expecting?
In fact, Your Lordship, there is already an order of court directing them to pay, directing the petitioner, the respondent to pay 60,000 per month.
This court?
No. The family
Yes.
court.
That is also not being
Not
paid.
paid, no, till now.
Regarding that, Your Lordship, in the lower court, we had, when the.
Okay, this issue, I think matrimonial dispute has gone beyond. I think it's irretrievably broken down now.
Yes.
So it is better solved through.
Yes, ma'am, the family court.
To the family court, who will approach?
We have already filed.
You have filed?
Divorce petition is pending, maintenance petition is pending, custody petition is pending.
Okay, we'll ask the family court to decide on the permanent alimony and give you divorce.
But so far as the washing of the order itself and it.
No, we are not touching that order. We are not touching that order. We'll say that the family court here, we have filed a divorce petition before the family. You have filed.
Yes.
Yes.
Is it on record?
Yes, my lord. No, the petition, I have mentioned it.
No, the mention of that, numbers and all.
Yes.
So how much will you be?
Your Lordship, in the family court, I am asking maintenance for each child in the sum of 2.5 per month.
2,500, 2.5 lakhs.
Per month.
Okay.
And as an interim alimony for the wife, 2 per month.
2 lakhs.
Yes, ma'am. And final alimony.
Okay, for that, what have you projected to be his income?
The affidavit of assets and liabilities is yet to be filed by them.
That is, you have asked this guy.
Yes, my lord.
But what is your reasonable expectation?
Your lordship, this man and the kind of living that the wife is accustomed to is unimaginable, my lord.
So it was like that.
Very high, man. He owns boutique hotels, he owns apartment blocks, he owns luxury cars.
No, you're
Luxury cars which the common man cannot buy.
We
my
are
lord.
contesting that. We are, and I am unemployed. It is my father's, everything belongs to my father. It is in my, since I'm the only son, it is in my name, but my father's income is not my income, your lordship, in the first place.
Okay, we will make the father responsible for the son's deeds.
Your lordship, and this is why
We have a mediation center here.
We tried mediation,
we
it
have-
failed. And it failed for a very simple reason, my lord. The respondent thinks that the village council court is supreme, customary law is supreme. He refuses to acknowledge the order passed by the trial court saying that you must pay 60,000 per month.
No,
He's saying
now with regard to determination of this alimony.
that is precisely the point, my lord. What the stand taken by them in the lower court is that the village council order is supreme.
No, your lordship, that is not the case.
That is
We
not the
are
instruction
only-
that they're getting.
We are only pressing on the.
Council, can you have instruction from your client? I may have a power here to
Yes.
determine the alimony finally.
Yes.
Can you get instruction about the reasonable amount for three of you?
In fact, your lordship, on the last occasion, the reasonable amount which the respondent projected is from the time of separation, 25,000 per month till now,
Yes.
and one final lump sum of 30 for all of them.
That will be
And
too
that,
low.
and the children should be, as per customary law.
That is the whole point, my lord.
They should be.
He also wants custody of the two children
Once the.
in
once
terms
they
of
reach-
customary law.
Yes, as per the customary law. Because, your lordship, the fact here is that in Nagaland,
Why are you not paying the interim? That amount you agreed
Yes.
to pay, 25,000.
yes,
That was
Okay.
my lord.
only on 4 people.
No,
Yes.
that offer of
Yes, yes,
25,000
Yes,
per month
yes,
as a bona fide thing.
yes, very much.
Pay that.
Yes,
Pay that immediately.
yes.
Pay that immediately from the date of separation till date areas. Within a week, you clear it.
Your lordship, in that case,
And we will consider about the alimony later.
Your lordship.
You get your 25,000 or you don't want that now?
Your lordship, there is already an outstanding order of 60,000,
Hmm.
which they have not complied with.
No, he is now making that offer.
But the judicial order is still there, my lord.
Where? Of the low court.
It is
Then
appealed
why before this court,
because of the village council order, madam.
that jurisdiction.
Yes, and your lordship, I mean, perhaps my learned friend has not been properly instructed, but the defense of the respondent is that he is covered by 371A and the decision of the village council court. So he is not entitled to pay anything. That is the stand, my lord.
No, your lordship, as per my information from my client. The only thing is that it should be decided in accordance with the customs and practices, and then whatever amount is to be paid, we are willing to pay. That is my case only before the lower court.
I got it.
It should not be very,
I
it should be realistic.
wanted to mediate, but now I think I'll have to adjudicate.
No, your lordship, I have no objection to the.
Okay, now tell me, jurisdiction of the customary court. Please, Abbas.
Yes, your lordship.
What is the jurisdiction of the customary court to hear this matter?
As per the clear provisions of the law, I have no objection. I am only saying that whatever
No.
amount I pay, I
No,
will.
no, no. You agree that the customary court does not have a jurisdiction in this matter. It should be under the Divorce Act before the appropriate court, appropriate forum.
Right, only now I
Either.
think that now only.
Done at council for day. We'll record that and we'll finish up this matter. We'll set aside that. We'll ask them to the proceedings before the family court. This happens.
Your lordship is, I would like to submit in this manner, your lordship. Your lordship has, this honorable court has, by the last order also come to the understanding that it should be it should be settled once for all, if possible, by this honorable court. and ask the parties to bring their, whatever their expectations is. The petitioner, on the last occasion, my submission was that the petitioner has not brought any amount that he is expecting to the table, whereas I have brought it before this court. So at least give the chance to the petitioner to bring his expectations and then give and take after.
That will not happen here.
Matter, we can.
That you do it before the family court. We'll interfere with this order, go before the family court, we will make a provision.
Your Lordship,
That-
my humble prayer is, now that I have already contracted a second marriage on the basis of the.
That will be subject to whatever happens.
Your Lordship, in the interest of justice, because if I may take your Lordship.
The interest of justice cannot be only for you. I'll have to think about the
Your Lordship,
two babies also,
your Lordship.
your kids.
My case is only this. In Nagaland, my children cannot become the children, children cannot become the tribe of the mother.
You both belong to two different tribes.
It's a different tribe. They are my children, we are patrilineal in nature and it is a tribal society. Now what happens is.
But I belong to a semi-matrilineal customary family.
Now, your Lordship, the problem here is all necessary certificates are to be issued by the village only in the case of children. Now.
How much would be your wife's expectation about the permanent alimony? Forget the interim thing, we'll take care. Permanent alimony, considering the status she was accustomed to, what would be for the kids and for herself?
Your Lordship, if you were to compute it in a lump sum, it comes to a very high figure.
You put that figure on the table.
And when I think about the figure that he quoted, they are worlds apart now.
You quote your figure. You quote your figure. We'll see. We'll test.
Even say, for example, Your Lordship.
No, if you can't offhand, tell me.
Yes, ma'am.
You get your instructions. We'll have this matter day after. You give me a figure, or give him the figure and come back on Thursday. We'll settle the issue, or on Friday, whenever it's possible.
Your Lordship, after tomorrow, I may have problems. I'm here till tomorrow.
When are you coming back?
I'll be coming back only on the 6th, madam.
Okay, we'll have it on 7th. 8th.
Otherwise, my lord, otherwise, the only thing, Your Lordship.
See, I was the other side
My lord.
2 years back. Just
I understand.
that gap is not much. So in such a situation, when this comes up, I understand that there is something more to that proceedings. So it's not a settlement that is being sought. It's also something more that you have done this to me. Wait, let's keep that apart. There are two kids. If it can be resolved in this manner, let us resolve it.
Your Lordship, what the village council, the order of the village
We'll
council.
set it aside, don't worry.
What the village council order says is that I have left the house of my own volition. I am not entitled to any relief.
Okay.
And this is the stumbling block as far as the proceedings.
Forget it. Now, let's hear it on merits. Let's only stick to the order before me. Validity of the order before me. Okay, make your submissions with the order. Mediation failed.
Yes, mediation order.
Not failed here also.
Yes, failed before, my lord.
Yes, what is your submission?
So only on the ground of jurisdiction, my lord. The order of the village council is bad in law, void ab initio, without jurisdiction.
Constitution of India.
Why?
Yes.
Yes, my lord. So I am here before this honorable court because I have filed divorce petition. I have filed a divorce petition. I have filed a
Before this or after this? Before this order or after?
Your lordship, the custody petition was filed before.
Hmm.
Custody petition was filed.
Before the principal family judge.
Yes, my lord. Yes.
Kohima.
Yes. No, Dimapur.
Dimapur. And divorce petition was filed later.
After the village council.
Ah.
So custody petition was filed and custody also only for the elder daughter.
Custody petition is number?
12 of 2023.
12 of 2023
Before the principal judge family court.
And what happened there?
So an order was granted for allowing custody to me. Yeah.
Of the elder daughter.
Yes, my lord. He had no issues with the younger daughter being in my custody. The respondent had no issues whatsoever as far as the younger daughter is concerned.
Okay, now come to page 18. This is the order.
Page
18.
on 8. The Dinki Village Council. Yes, my lord.
Dungi Village Council.
Yes, ma'am.
Now, what is this projection made that this is an order under Article 371(8), 2 and 3?
Precisely the point, my lord. Article 371A only lists.
That does not confer any power. Power would come within the provisions of the subsequent act, you know. Yes, Council.
It should come under the.
So this order, very invocation of the power to pass this order is wrong. On that count, it will go.
But if at least the village, the court has jurisdiction under specific provision of law, then.
Yes.
Then in that case.
Have you taken a plea on this revision petition? Have you taken a plea on this? You have taken a plea. And what is your answer to that?
My answer is.
371A.
He says.
Your lordship, it is not 371A, your lordship. I have given my.
Okay, Mr. Council, what are your other submissions? Why is this order bad?
No jurisdiction. Village council has no jurisdiction to take up matrimonial issues. The Indian Divorce Act of 1869 is applicable in the state of Nagaland. There is already a decision on this court, and that is the decision in the case of Nyoto Sema versus Karli Sema.
That earlier, 1918.
Yes, a earlier decision. And this order clearly holds.
Today also.
Yes, ma'am.
Then second.
The second one is the second judgment, Your Lordship, 2022.
Justice Burgos.
Yes. Justice Burgos. On the same point.
On the same point with regard to the House of.
The House, on the same point. And this honorable court clearly holds that the courts empowered are the courts empowered under the Indian Divorce Act and none other.
No. Okay, then next.
That is the only point.
Only point. Okay.
That is only.
Yes, your reply.
Your lordship, I'll take your lordship to my affidavit. The specific statements which I have made, the sequence of events, how these things happen.
I'm not with the merits. I'm with the jurisdiction point. Satisfy me that the village council had jurisdiction to counsel a decision.
My case is that under the village, under this 1937 rules, the Village Councils Act.
What is that?
The Village Council's Act is at page 60 of the present
This book.
village courts, page 60. This is with regard to village court. So a village court shall try all suits and cases following the customs and usages applicable in deciding such suits and cases. The village court shall try and decide all suits and cases after hearing the parties and your witness, if any, and shall so. One, your lordship, a village court shall try all suits and cases following the customs and usages applicable.
Now,
Deciding such case. Now,
if there is a dispute,
yeah.
say a village code of a particular tribe will have particular set of norms of that tribe applicable. Say all the village codes will not apply a uniform norm. You say he belongs to, she belongs to a different tribe, you belong to a different tribe.
The Naga custom is that once a woman is married to a person belonging to another tribe, she becomes that tribe.
Or it gets converted, is that true?
That is the custom.
Fine.
And she also adopts the village of the person who.
That is
it is
correct.
automatic.
In fact, in my writ petition, I have taken a specific plea that I have never resided in Dunki village.
Okay.
We are not residents of Tungi village, but we.
Okay, what is your village codes?
Come under the. Because everything, the procedure, your lordship, the.
Okay, we got it. Next point.
Certificates, all necessary, everything has to be issued by the village.
Okay,
Yes.
the next point. Next point.
So, next point is that as per the customary law, your lordship, when a divorce is to take place, normally before going to the village court, it is the relatives who come together and they decide. This is the procedure that has been adopted since time immemorial.
Show me a decision. Show me a decision of this court or the Supreme Court or anything that the application for a divorce can be considered by the village court.
Your lordship, there are no decisions. There are no decisions. I have no decision because these matters, normally it is settled in the family itself. So the two cases which my learned colleague has submitted, these are the only cases which are.
So that goes against you.
Your lordship, that goes against me. Now, your lordship. Even with regard to who gets what property, everything is.
That's different. That is different.
As per the custom.
But with regard to divorce, now at least we have two decisions placed and you agree to that.
What happened was, after this village council, I would like to take your lordship to even the pastor who solemnized the marriage, both the families agreed to let him mediate and bring about a reconciliation. The wife, the petitioner and her family refused to even go by that. If your lordship.
Has he appeared before the family court?
Yes, we are appearing, but your lordship, in this case, marriage took place on 5th of December, your lordship. They filed this writ petition in November. If your lordship may look at the date, it was filed in November only. The marriage took place in the month of December, December 5th. I'll take the lordship to the dates on which this.
No, it's okay. It's okay.
Now, what happens is, if it is interfered with at least divorce, he also wants a divorce. So if this honorable court may only pass appropriate order for determining the maintenance and the rest, without interfering with the.
You both
What
sit
the-
down. I have given you, she says that she was accustomed to a very high standard of living. And the law is that she must be compensated to that extent so that she can maintain that standard. The amount for your daughters and her. Settle
Your
it.
Lordship, with regard to the-
30 lakhs would be peanuts for you.
No, Your Lordship, that is not the position, but anyway.
No, but that is, I tried, but that is a controversial issue. Both the petitioner and the respondent.
Regard to the second marriage, Your Lord. If this honorable court will consider that aspect.
We cannot, we'll only consider whether that order is with past jurisdiction or without jurisdiction. Wow, that's all. And the rest, you have proceedings pending, that will take care.
Your Lordship, the human aspect, because this is bound to.
The human aspect, this court has to keep in view. You will also have to keep in view the human aspect of your own wife and two children while determining okay, I'll give you one more chance. I'm doing the delivery of the order till Thursday. By Thursday, arrive at a compromise and tell me.
I appreciate that, Your Lordship,
Hmm.
but I know it will not work out.
Mr. Counsel, the more you say, the more I find that the wife is also not interested
No.
for a compromise.
Well, the wife is interested in the mediation proceeding. Your Lordship, what happened in the mediation proceeding? The husband and wife, they got together.
What has happened has happened. There is still a tomorrow.
True, my lord.
Okay, no need. If you can't settle it, make a, you need not be here, your junior can make a statement. I'll pass the orders on Thursday, on merits. So before Thursday.
If they may bring their proposal.
No, you directly, if required, get it settled by Thursday. Thursday, second half, I'm passing the order on merits.
Then if the matter.
I will get my hand back because I just want to go through the loss once and thereafter pass the order, that's all.
Question. If this honorable court may direct it to the mediator also, I am not averse to it. Your Lordship.
That mediation is
Not
gone.
averse to it.
That is gone. Heard the learned counsel for the parties at length. Hearing concluded. Registry to list this matter again on Thursday, 2 p.m. For receiving for permitting, for allowing the learned counsel for the parties to make any further submissions in the matter as requested. I'm just putting it in this way. So get your proposal settled. Come back. See, Mr. Counsel, you have agreed to the proposition that the village court may not have a jurisdiction because of those decisions. So let us not precipitate the matter further. You and Mr. Counsel, please, hardness will only, your rigid stand will only, I know you will be hurt very badly, but there are two kids. Think about them also.
Yes.
So please have if there is possible in amicable settlement, please tell me that yes, we are proceeding. If required, I'll adjourn this matter. I'll make it CV and I'll keep it. There is no problem. But if it can be settled, settle it by Thursday.
One more, Your Lordship. From the second marriage, a child has been born.
That is for you to make a better settlement. I'm not pressurizing either of you, but I'm giving you an opportunity. Then talk.
It has to be reasonable, and without them bringing it before.
Why court? Children are yours. You have kept them at a very high standard of living. They are accustomed. Think about it. Finish it Friday, Thursday. Just give this file to me. Yes. Oh, okay. Yes, Mr. Bora, कितना item है यार? One more. Yes, they take that also. There are no more matters. We'll finish that off. Yes, Mr. Bora. Who is for your respondent?
I'm for the, I'm appearing for the bank of order. Your Lordship, as far as the settled principle is concerned,
Settled principle, we'll have to read it along with the condition attached. That order.
my lord.
In that order, there is a condition attached. Now that condition not being fulfilled, that order is null and void. It remains, it goes back to the earlier stage.
It does not, my lord.
Should
I mean, my lord.
That I'm not sure. There are decisions of the Supreme Court to that effect.
They are just, of course, we say it cannot go back. Once.
No, when it is a DRT matter, there is a compromise with a condition. Now that condition not being fulfilled.
My lord.
What will be the effect?
My lord, the Honorable Supreme Court says there can be no conditions. It has to be just an award. The Lok Sabha proceeding, the Lok Adalat proceeding is by way of conciliation.
No, that I'll get you the judgments on that.
Very well, my lord. May I place my judgment straight, my lordship, so we don't have to waste much time.
We are making some preliminary objections regarding maintainability of writ petition challenging in section 14 notice. Here is the forum.
Now, one thing, there is a attached condition also. There was a Lok Adalat.
Yes, my lord, this is a Lok Adalat.
That Lok Adalat settled the matter. But
The petitioner did not honor the settlement.
Okay.
So it is not basically, your lordship, my case is that it is not an order of the Lok Adalat, of the DRT.
It's a Lok Adalat order.
Yes.
There's no dispute on that.
Yes, ma'am. So
But
therefore,
once that Lok Adalat has passed that order,
it cannot revert back to the referral court.
now give me a situation.
My lord.
Give me a situation. It's not going back to the referral court in that connection because it need not go. They can automatically under section Securitization Act 13(4), they can take over the property
No, my lord.
and they can proceed.
Not anymore, my lord. Once a matter is referred to the Lok Adalat, the only way to enforce it is by way of execution.
Okay. The execution would be, according to you, 36 lakhs.
Yes, my lord.
What about the subsequent condition?
Bad in law.
Why have you not challenged it?
I have challenged it, madam.
Where?
It's here in this petition.
Today? How can you?
No,
That is already gone.
No, it is there in the petition.
That cannot be. We will not permit that.
It is,
The condition of 13(5)2023 order, that is not permissible after your default to be challenged.
Your lordship, I'm not on that point. I'm not on it. My point is this. In the very first instance, in the Lok Adalat award, that clause could not have been inserted. That is my point, my lord. The Lok Adalat could not have issued the award or framed the award.
You mean to say that this award, if not implemented, or if you have not complied with it, the only way for them, out for them was to be, this being a civil degree,
Yes, my lord.
to go for an
Yes,
execution
my
process.
lord. That, and in fact, if I may, with the greatest respect, my lord, that is the law settled by the Honorable Supreme Court.
Just show me the Supreme Court decision to that effect. In context of a DRT proceeding,
Yes, my lord.
which is the one?
I've called out the principles. We can go to the text. my lord. The first one, 2008, 2 SSC 660. The Lok Adalat should guide and persuade the parties with reference to principles of justice, equity, and fair play to compromise and settle the dispute. It cannot assume a judicial role. No judicial orders can be passed, my lord. An order of the Lok Adalat which is contrary to law and beyond the power and jurisdiction of Lok Adalat is void in the eye of law. An award of the Lok Adalat is final and binding the parties and becomes executive.
What is the compromise date? Page
19.
19.
19 is the order sheet, page 20. 19, yes, madam. 19. Both 19 and 20. 19 and 20.
20 is the
Now come to clause 5, page 20.
Page 20, yes, ma'am. Clause 5.
What do you say on this?
That the bank's claim, you know, that the bank's claim as to the subject matter will remain unaffected and surviving. This is wrong, my lord. This is what I am saying.
Hurry, this is signed by you. You signed it.
I agree, my lord.
This is a compromise.
I signed.
This is a look adalat. You both agreed
Well.
that we will compromise this matter in this manner. You went before the look adalat, before the court.
I did.
Court accepted. Okay, this is the compromise. How can you resile back from this now?
The compromise also has to be in accordance with law. That's what I'm saying.
I'm sorry, this is signed by you.
True, my lord. True,
I'm
my
sorry.
lord. It is
That
signed by
cannot
me.
be.
It is signed by me. But I am saying, what I am saying is this, my lord. This part has the effect of setting aside the Lok Adalat award and having the matter reverted back to the DRT, the reference code. That is my case, my lord.
Okay, fine.
And that is
We got it.
impermissible in law. That is what I'm saying. And in fact, your lordship, in this case, another case.
And another thing, this 13-4 notice of section 14 order, you are challenging only on the count that the amount that is reflected therein is more than that which was compromised.
No. I'm not saying that, madam. What I'm saying is this.
Mr. Counsel, this decree which that is now being, say that is allowed with 36 lakhs. They need not go to file an execution. They can always take recourse to 13-4 from the securitized property. They can always recover that amount.
It is my case, my lord, that course of action is no more available to the.
How?
Because of the finality of the proceedings of the Lok Adalat.
Okay. Now let us take it in a different manner. When an OA is filed before the DRT, claiming say 80 lakh rupees, 90 lakh, 1 crore, the A is allowed. A judgment comes, that is also a civil decree. Now, if that is not complied with, what option do they have?
Recovery proceedings.
How? Because that judgment is passed.
Yes, ma'am.
That should be the end of the matter. If they have to file an execution proceeding there also.
The proceedings under the surface are quite different, madam, as your lordship is aware.
That's what I'm saying. This Lok Adalat order will also, once that decree is done, it's not fulfilled. We'll go back and the matter can be settled under, for 36 lakhs. I'm not saying for the earlier amount. 36 lakhs. Let us say the certificate amount. This is the certificate amount now.
Yeah.
That certificate amount, they can always recover from the assets, secured assets.
That 36 lakhs I have already deposited in my wife's account, madam.
Your wife's account, they have disposed of
The
it.
instruction.
No, that they have denied.
They deny that.
That is no point. But now this 36 lakhs, let us forget the other part. 36 lakhs is permissible to be recovered from the securitized assets by them. Because it's a decree of the DRT now.
No, madam. There I beg to differ. It is no more a decree of the DRT. It is a Lok Adalat award. It is no more a decree of the DRT. That is my case, madam. It is no more a decree of the DRT.
Okay, these are the decisions you want.
Yes, madam. And in fact, it is a very interesting case. This is from the Patna High Court.
That division bench has.
Division bench, yes.
Division bench has.
A case of an award.
That was award there, then the court was extending the period of.
The award was obtained by misrepresentation.
Oh,
And was not to be modified by the.
That the Supreme Court said nothing. We can't go beyond that.
Yes.
Because then the factor was that 96,000 odd he deposited.
Why not?
Yes, Mr. Bora, what is your case? Forget the technicalities, we are in hearing now. Come to the meat of the matter.
Initially, the Lok Adalat order was not challenged. Then they filed an amended petition. Thereafter, this order has been challenged now. But if we come to the order at page 18 and 19, basically. Here the dates are very important.
You are compromised.
Compromise did Lordship would see point number 2.
Hmm.
It was of only 6 months.
Hmm.
Within 6 months from 13/5/2023.
Hmm.
Now 13/5/2023, 6 months completes on 13/11/2023.
Hmm.
Now he did not, the validity of this order was till 13/11.
No, he says, the council's argument is different. He says that this being a compromise in a Lok Adalat, the LSA Act would apply. If that applies, the Supreme Court has said that is sacrosanct. Until and unless the agreement is not shown to have been arrived at by way of fraud, misrepresentation, coercion, that will hold the field, and that is the only amount you are liable.
Yes.
His further submission is that, okay, I defaulted. Why did you not immediately take steps for recovery of that amount of 36, whatever it was agreed upon, and taken away your dues, maybe from the securitized assets itself?
Yes, Lordship. Regarding the first.
That part that the securitized assets would not be there, find it very difficult to, because that mortgage property will remain, the loan is liquidated.
And moreover, even if it is a decree, suppose there is an execution proceeding for banks, Lordship, a special like.
Show me any decision which says that under these circumstances, the earlier amount, the original amount for which the OA was filed would revive.
Yes, Lordship, the Lok Adalat compromise settlement has certain conditions. He has put his.
Show me that in the event.
I'll just point out the dates. Now on to August 2024, a section 14 notice has been issued after the period of validity is over. Now there is no Lok Adalat order. Lok Adalat order was still there till 13/11. After there was no.
That is only one way of looking at it.
Lordship, I am coming to it. Now the Lok Adalat order has lost its validity. We also cannot act on that. Being a party to that, he has agreed, he has signed.
Show me any decisions.
Now, and in the pleading itself.
Okay, fine. We got everything. We have got the rival positions. Now show me any decision.
Lordship, secondly and most importantly, he comes here on issuance of section 14 notice. He has to go to the DRT. There, I have brought the decisions of 2024 also. We'll
consider that.
Get enough decision.
That latest decision of the Supreme Court that if this proceedings, the magistrate is only a executing authority, not an adjudicating authority. We got it. Now, that a plea has been taken by the petitioner, that being a Lok Adalat settlement, LSA, the amount, you cannot go back to the earlier amount, this has to be there. And the conditions, he says the conditions are OTS, be that as it may. Now you show me a decision of the Supreme Court that, yes, it is permissible.
Yes, Lordship, I'll try to do that. But during the validity, he has to show it, or before signing, he has to show it. After he has defaulted, Lordship, how he can rely when the compromise deed itself has lost its validity?
Two things. Show me a decision that a compromise with a condition is permissible. And if the condition is not fulfilled, there are decisions of the Supreme Court.
Yes.
If the condition is not fulfilled, the bank reverts back to its earlier position. Just give me a decision on that. You can give it to me online tomorrow.
Yes, Lordship.
Then I'll reserve the judgment.
Yes, Lordship. And
this is the only issue.
And Lordship, and one more thing, Lordship, I'll also give the judgment that section 14 notice can never be.
You will come to section 14 notice. First, get me through the bridge first.
Yes.
Bridge which the council has built. Right? When? Tomorrow? Thursday?
Lordship,
you need to come. You can send it.
Yes.
With the concerned decisions, they will take care of the rest. You can move peacefully. But the Learned Council for the parties at some length. Mr. B.P. Bala, Learned counsel representing the respondent bank submits that he would submit his written submission along with the citations relied upon by on Thursday date. Registered to list this matter again on Thursday. If you require, you can also give me a small note.
But I already made my submission.
You made
So
your
that's why.
submissions. You give me.
Very grateful.
And that day I'll just, if possible, I'll deliver the order. No, I'll keep it, I'll give it to you next week.
Very grateful, yes, for that much time. Very grateful.
Thank you.